Click the like button, share and subscribe. It's free.
Excluded everyone that was in the house. What it indicated is that that DNA was left by someone else other than the person who were in the house, the persons who were inside the house. That DNA was obviously at a later stage, my lord, when these accused were actually now targeted. Their DNA were taken for comparison. I suppose when we get to that stage, I will deal with it, my lord, because as much as certain findings were made by the specialist, but they were pointers by the specialist to say there are common things that you can find on these people. And for me as an investigator, it was good enough that even if it's 1 or 2% of the DNA, for example, pointing accused number 3, it is enough for me to convince me that he was there as an investigator.
That is not his terrain. It is exclusively not his terrain. He's repeating the very same thing that I cautioned about. Mr. Gininda is not here as an expert, madam. He's here as a police officer. He only needs to bring information to the court, the basis on which this court then will have to make a decision. He is not here to analyze that information as though he's the one that is going ultimately to give a judgment. He's pretty wrong, and the state is allowing to do that. I don't know if the state is doing that with a view in order to influence the mind of the court. But I'm very grateful because the court said earlier on that the court is well trained and it is experienced enough to separate the wheat from the chaff. What Mr. Gininda is doing now is only trying to influence the mind of the court with a hell lot of a chaff. What is stating now is a chaff. Is nonsensical. It should not be done, my lord. And I'm going to request the state to tell its witness to refrain from what the state's witness is doing, my lord. Because it's not here as an expert, and we're not interested in his opinion. His opinion matters not. Ultimately, it is going to be the duty of the state on the basis of the evidence that Mr. Gininda would have submitted to this court to argue what he is now trying to argue. Otherwise, Mr. BALOI needs to get into the box and Mr. Gininda coming to the point where Mr. BALOI is standing. They need to swap positions. But what he's doing now is pretty nonsensical, my lord.
Okay, yes, let's see the state. What's the state?
As a complete malota, I think very fresh on the article that the court referred to about courtesy in court. One would have expected Advocate MNISI to refrain from using words such as nonsensical, no matter how strongly he might object to the evidence. I think there's still a duty to show courtesy to the witness and the court. That is the first thing. The second thing is the court had asked this witness a question in elucidation, and the witness was in the process of answering the question that was posed by the court. And thirdly, as Advocate MNISI pointed out, that the court has mentioned that it's trained to separate evidence from opinion evidence.
Usingeneke kodaba ke ukuthi ke ufakazi besaphendula ke umbuzo inkantolo ubuzile esho ke ukuthi ke kwakunezinkulumo ke eyayikhona ke lana futhi ke kukhona ke nale information eyayikhona ke kwidokodo okwami ke kwakuukuthi ke manje ke ngithole ke ekuyikona kodwa ke ngingalandeli izinsolo ezikhona noma izinkulumo ezikhona ke ukuthi cha abekho abantu ababengenile lapha yana kodwa ke ngibheke lokho okukhona ke kwidokodo bese ke manje ke ngibheke nalokho ukuthi cha akunabantu ke ababengenile manje ke unabantu ababesendlini ke abashoyo ukuthi omunye wabantu ababephakathi ke endlini wayenama dreadlocks ekwakuyena ke owayephethe isibhamu ube nabo omakhelwane abathi ke kulabo abantu abababona ke bephuma endlini ke ukuthi ke noma sebegijima ke noma bebaleka beya kuhlangothi oluthize omunye wabo wayenama dreadlocks aqhubekeke futhi esebenziseke ukuthi kwakufanele manje ngibhekeke ukuthi ke manje kuloko okhunywa yilabantu ke kuyinhlangothi ezahlukene uthi ke kwabe kusekhona nalobufakazi ke bolibefuzo noma ke phecelezi ke iDNA wabe esenza ke ekhuluma ke ngaye umsolwa ke wesithathu ekula ummeli wakho asukume khona ke ethi asithi ke mhlambe bekukhona kukhona-ke okwatholakala laphayana kwi-DNA leyo, noma-ke u-2% kumina noma u-1%, kodwa nje okusho ukuthi yebo-ke wayekhona-ke, wabe esesho ukuthi asithi-ke mhlambe umsolwa-ke wesithathu ekula ummeli-ke asukume khona-ke ukuthi nje lokho loyo 2% kumina-ke wawanele-ke ukuthi ngisho ukuthi yebo impela wayekhona lapho.
Thank you. The state will request that those gratuitous and unbridled insults by Advocate MNISI regarding the witness be ignored, my lord.
It is no insult. The word nonsensical is there in the dictionary. Mr. BALOI is not aware of it. I can refer him to that word. And the definition of that word simply means that it makes no sense. It is nonsensical. I don't know how insulting that word is, man. And I heard him mentioning that there's an article on a Sunday that he read regarding court ethics and stuff like that. That starts with him. He knows what the duty of a witness who is an investigating officer is when that witness is giving his evidence. It is Mr. BALOI's duty, first and foremost, as a leader of that witness, to lead that witness specifically on what that witness should come and tell this court, not to allow that witness to be on an escapade and wantonly come and give evidence that it is not in his terrain to come and give. Mr. BALOI has been allowing Mr. Gininda to give opinion evidence. Mr. BALOI has allowed this witness on a number of occasions to come up with suggestions that the evidence that is already before court demonstrates that accused number 3 was involved in this matter. He now mentions DNA. Previously, he also mentioned a firearm. It consistently allows this witness, my lord, to go on an escapade on evidence that it's, at this stage it is inadmissible. It's basically giving this witness a role that he himself should actually be playing. For instance, the court has simply asked a question about Mr. Ngachi, whether or not he was still alive or what. This witness now goes out of the rail. It goes out of the question that the court has specifically asked. And Mr. BALOI allows that to happen. And then he stands up and says there's an article that has been written by the honorable judges of this court on how ethics is. I am not here, my lord, representing myself. I am here to represent the interest of accused number 3. And I cannot allow witness such as evidence such as the one that is coming from Mr. Gininda to go through the record and me sit it down here. I'll never allow that. Otherwise, I'll be doing injustice in the representation of Mr. Mngube here. But first and foremost, it starts with Mr. BALOI himself. Thank you, my lord.
Save time. I will then proceed. I've already mentioned that the witness was commenting on the question that was asked by the court. We had already moved to the situation of accused number 2 when the court asked this witness to comment on something. We cannot interrupt the witness when he answers to a question that was answered by the court and to which the court is entitled to ask. That is the simple fact of the matter. And as we pointed out, my lord, we don't understand the objection that was raised by Advocate MNISI. As the court pleases.
I will make declarations and conclusions regarding the evidence tendered in this court, whether that evidence proves or disproves anything. And I'll quote the reasons why, if I agree or disagree with that evidence. Okay.
Thank you. Ke uzothatha ke isinqumo-ke ukuthi ke ubufakazi obethulwayo-ke lobo bufakazi buvumelekile noma cha, ngizosho futhi-ke nangokomthetho ukuthi umthetho uthini mayelana nalokho.
As the court pleases, my lord, I agree with the court on that it is the duty of the court to analyze the evidence, my lord, at the end of the case. However, my lord, I'm also standing on the point of objection so that it will go on record that it was pointed out, my lord, during the trial stage, that what the way that the evidence is elicited at this point in time is not the correct procedure, my lord. Especially, my lord, the reference that has been made by the witness to the Ngashe senior witness, my lord. That statement was never handed in this court. There was no application for the handing over of that statement as hearsay statement. So in other words, my lord, it is not proper before this court. And the witness has made reference to the content of that evidence.
Yeah, Nana, where do I get the evidence? I got the evidence here.
Yes, my lord.
When I came to know that there's a neighbor who has made a statement, who actually also had a commotion, and there's another neighbor also who saw the deceased with his back in a white skipper or sweater,
Yes.
in the kitchen and had commotions. Somebody jumped into the yard and ran outside again. But the evidence of being a policeman who was there, I heard it from here. Am I right or wrong? I mean,
Yes.
how would I know otherwise?
For the one for the police, my lord, I don't have objections because those police testified.
No, Mthetho and that gentleman, I don't have
Yes,
a problem.
yes, my
I
lord.
mean, Ngashe.
Ngashe,
Because
yes,
I wanted
my
to know where Ngashe is.
Yes.
And I was told that he's deceased.
Ngashe is deceased, my lord, and his statement was never submitted to this court as evidence, my lord. And therefore, no reference should be made to that statement or can be made to that statement, my lord.
When you say no reference should be made to that statement, no reference should also not be made to the evidence of the son of Ngashe. What's his name, by the way? Kaya. Kaya said, I was with my father. I remember that evidence.
Oh, my lord, the son is alive. The son has testified.
You don't know what I'm getting to, you see.
Oh, sorry, my lord.
The son also spoke about the father.
Yes.
Having seen whatever.
Yes.
That's all. And then the father is dead.
Yes, then let's correct the record, my lord. If we are making reference to the evidence of the Ngashe's son, then it must be directed to that portion of evidence that Ngashe's son said 1, 2, 3, 4, and 5.
Okay.
But a reference being made to the statement made by senior who passed away and his statement has not been submitted as evidence. My lord, I'm raising an objection
Okay,
on that
fine.
point only.
Fine, okay.
Yes, my lord.
Go on.
And then also, secondly, on the issue of this witness giving analysis or making reference to the expert evidence, my lord, which is the forensic evidence which was led in this court, who is now saying, out of that expert evidence, I can be able to say 1, 2, 3, 4, and 5. He's not an expert, my lord. He's not allowed to make any reference and to analyze on that part of evidence. He's just a police officer, this one, as the court pleases, my lord.
All right, yes, Mr.
As a court, please, we really don't, the neighbors that the brigadier is referring to have already testified, Ms. Nthabise Mokete as well as Ms. Kaya Ngashe. The evidence is already on record. As far as the analysis is concerned, the witness is merely saying that those are, the expert has already testified. The DNA analyst has already testified. The witness is merely giving a summation of the reason why he was persuaded that there were no, that there were intruders. That's the simple fact of the matter.
Court can give indulgence, my lord. I just want to say, perhaps, my lord, to assist in that what was said by Advocate MNISI, because that's exactly how I'm viewing it. It is insulting. For him, the word nonsensical or nonsense may mean something else if interpreted, but I think the context of how it's said may give a different meaning. I feel it's insulting and disrespectful. I don't think I've done anything contrary to being respectful to Advocate MNISI ever since we started to deserve that. And I just want to request that we maintain the decorum of the court. We may differ with what I say. He will have the opportunity when he cross-examine me as to why I said that, why did I base those expertise, and challenge me on it, my lord. And the court will then make a ruling. I was simply making my observation, not testifying as an expert, to say these were the pointers that convinced me that they were intruders. Not that I was saying, my lord, the expert or whoever did the work were wrong or right. I was simply saying, after the matter was given to me, I had to analyze and make a decision as to whether indeed there were no intruders or were there intruders. And if there were no intruders, my lord, I would have given the same evidence to say, this is what I have, This is what the DNA is saying, and based on that, I was then convinced that there were no intruders. But in this instance, I'm simply pointing things that convinced me that there were intruders. Not that I'm reinterpreting or testifying on behalf of the expert. It's simply that, my lord. But the mere point of my statement, my lord, is just to to request that we treat each other with respect. That's all, my lord. The difference is, I know we will bump head with my colleagues because we're on the opposite sides. But at the end of the day, it's nothing personal. It's in the interest of justice and to help this cause to come to a just conclusion, but not to treat each other with disrespect. That's all I need to ask, my lord.
Engizocela ke ukuthi ke mhlambe ingaba yiyona ke inkantolo engangilekelela ke noma ke ukuthi ke kwenzeke ke lokho ukuthi ke ngicele ke ukuthi ke kube khona ke inhlonipho ngoba ngendlela ke akhulume ngayo ke umnumzana ke MNISI ke ngegama ke lelo alibizi ke umisho ngendlela ethize kodwa kumina ke kubonakalisa nje ukuthi ke ungabi khona kwayo ke inhlonipho akukho ke sengikwenzile kuzofinyelela khona manje okungathi ke kuholele kuthini ke mina ngimhloniphile noma angenza ke lokho mina ebengikwenza bengingaphikisani nobufakazi bakheke ungoti mayelana ke nolibofuzo noma ke iDNA bengichaza noma ngiveza nje ke izinto ke ezibe khona ezibe inkomba kumina ukusho ukuthi yebo babe khona abantu abangena kuleya muzi noma kule yandlu noma ke bekuwukuthi babengekho ke bengizonikeza ke ubufakazi obufanayo ngithi yebo ke ngenxa yalokhu ke ngithola ke ukuthi cha abekho ke abantu ababengenile kuloya muzi ukucela nje ukuthi ke nje kube khona ke nje indlela yokuhloniphana la enkantolo.
My lord, the witness is referring to a theory of which maybe needs to be unpacked, whether it was the investigation that revealed that evidence or it is a hearsay evidence through the investigation. Because, my lord, if the witness says after signing the docket, there was a theory that a person who shot the deceased was inside the house. So the objection is on the fact that it must be cleared whether it was part of the investigation which led to that theory, or it was the hearsay, or it's the evidence they had. As the court businessman.
I'm baffled by that objection. It's already on record that there were two theories, and the witness is just merely rehashing the mandate that was given to them. And I think the objection is with respect premature. The witness will deal with all these aspects.
Why do you say it's hearsay evidence?
My lord, I was saying because I do not understand the theory, what the theory is. My lord, that's why I was saying at least if it can be unpacked, that it was as a part of the investigation or part of the evidence they had as investigating team, my lord, so that one will understand whether it amounts to a hearsay or what type of evidence, my lord.
He says on a report made to him on assuming command of the investigation that there are allegations, you don't want to call it a theory, there are allegations that the person who allegedly murdered the deceased was inside the house.
Yes, ma'am.
Is that what you're saying, sir?
That's what I'm saying, my lord.
My lord, then if it was a report that was made to him, then it has to be disclosed. It's a report by who?
Yes, sir.
So I still have to support the objection of my learned colleague, Advocate Mshololo. Somebody must have actually made such a report. Who is that person for one to make a conclusion that this exists as a theory?
My lord, we need to look no further than the proposition that was put by Mr. Mshololo himself.
What did he say?
That Longway is the person who shot the deceased. Now, this is what the witness is saying, and now there's an objection.
This is examination in chief.
Yes.
This is examination in chief. This is the new evidence brought by Brigadier Gininda in chief in the main trial.
Lord, we have a lot of ground to cover. We're not going to detain ourselves with such trivialities.
This is not a triviality. I think the state probably used a very inaccurate term there. Because we're also concerned about the source of this report to the effect that the shooter was one of the people in the house. What is the source of that information, or who is the source of that information? That's our concern, because we cannot treat this as just a mere triviality.
I'm not sure if such report has been handed over to the police.
However, my lord, if I may just ask my lord leave to make just a few submissions, my lord. If there is an objection, my lord, between counsels, the objection is between the parties, the defense and the state, and the ruling will be from the court. The witness is not allowed to get inside and give explanation unless it's invited by the court to do such, my lord. Thank you.
Yeah, let's finish what you're saying. Yes, my lord. So I was saying, my lord, that is out of context, because the facts of the matter contained in this docket, and these are the facts, they point that the person with the dreadlocks who went inside that house is accused number 3, Mr. MNISI's client. There are statements in this docket. So to say I'm making whether an assumption or an opinion is selective in that, and I don't think it's in the interest of justice, my lord, with greatest respect to him, because he's sitting with the facts that point in terms of the statements. Mr. Zungu, Sizwe Zungu, I mean, it was before this court, I was not here, but the statement indicates what he knows. The firearm that was used as a murder weapon is linked to accused number 3. He's
Objecting. That is totally irrelevant. That is totally irrelevant for this moment. How does it say that the firearm is linked to accused number 3 when that aspect is being investigated? No, that is totally irrelevant, my lord. And this witness, my lord, is going to tell him disrespectful to this court, because they can only speak to the court through the prosecutor. What is doing here is total disrespect of this August House. And I'm going to request the court to tell him to refrain from doing that. Because now he's saying the firearm in question here is linked to accused number 3. Where does he get that from? Where does he get that from? Because that aspect is still being investigated. It's total disrespect.
We'll get to those aspects, Brigadier. But if I can then ask that we return to...
Yes,
I think I'm going to object. And I'm raising an objection. Investigating officers, their primary function is to investigate and bring objective evidence before court. It is for the court to analyze that evidence. What this witness is now doing is embarking on a process of analyzing evidence, which that should be left for the court after the court has been after the court is seized with that objective evidence that came from the investigating officer. It is not their duty to assist the court on how to analyze that evidence. They are taking over what the court is supposed to be doing. We are expecting Mr. Gininda to say, in the course of our investigation, this is what we found. This is what we found. This is what we found. This which we found is how it connects accused number 1. This is how it connects accused number 2. This is how it connects accused number 3, 4, 5, etc. It is not for him to come and opine as to how the evidence that they found is relevant with the connection of each of the accused person here, madam. It's basically usurping the duty that the court should embark upon after having had all the evidence at the end of the case, my lord. I'm strongly objecting to the process that this witness is embarking upon.
But be that as it may, my lord, what the witness is merely trying to explain is what he explained yesterday. He says there appears to be a misunderstanding, so he's just merely rehashing the explanation that he gave yesterday when Advocate MNISI was objecting. That's all that is to be, my lord.
Just repeat what he just said so that we all understand it.
My lord?
Yes,
definitely does that, my lord. And may I make an example so that as we go forward, my lord, then we are clear on the process that we're supposed to be embarking upon. He testified yesterday, I think, and referred to Mr. Mube, and said that some witnesses in the house, they got information, or also in the statement that he went through, that is contained in the confession, one make of the statement speaks about a person with dreadlocks. And in his view, he specifically said that, and in his view, that person is accused number 3. Should that not be actually be left in the domain of the court? We're not interested in his views. All that we're interested in are facts that he has collected, evidence, my lord. It could be direct evidence, it could be circumstantial evidence, or what other form of evidence, but we are only interested in the evidence that is bringing before court. We're not interested in his views. That is why I'm saying, my lord, it's basically usurping the function that it should be seized with the court. It's basically saying to the court, this is how the court's judgment must be penned. He's penning his own judgment, my lord. I don't know for what, because he's just an investigative officer. He's only here to assist the court with facts and nothing else but facts. Thank you, my lord.
Family, our country is heading for dogs. We have a judge who cannot hide his biasness. He's always on the side of the witness, Brigadier Gininda. And Brigadier Gininda is allowed to write the judgment on this case, and is being allowed by the prosecutor and the judge. There's no way they want to stop this guy from writing this judgment. He's been doing this, and no matter how much the defense complain, the judge still allows such things to happen in his court. What kind of a judge is this? How do we get investors in the country when investors all over are watching what is going on in this court of South Africa? Because there's no investor that can ever invest his money in a country that is lawless. Why is the government of our country allowing this judge to do this? Because not that they don't see this. It's everywhere in the social media. Everybody's complaining about it. And the person who died was a celeb. And he meant a lot in the country. Because he was in the national team of the country. A well-respected person. And as such, the family of the Maiwa, after 10 years, they still didn't get closure as to how their son died. And we get a kind of a judge in court allowing this kind of evidence, allowing such a poor evidence brought in court, and allowing the same witness to write judgment for the judge. And the judge is allowing that. And the judge has been cautioned several times by the same defense. And he can't hide his biasness. He even laugh about it, what he used to do before. He was always winking to the same witness, guiding the same witness, doing all this kind of biasness while camera are watching him. What kind of a judge do we have? He always bragged that he has so much experience, but we don't see that experience. What we see the true reflection of a biased judge in front of the court, doing all this kind of things. I wonder if the Maiwa family will ever get justice as to who deleted their son. Because up to now, we are not getting answers from this judge. This judge is supporting a narrative that is false in court. We know very well, eyewitnesses who were there, they said the gun that was used was a revolver with a wheel in the middle. But the gun that has been taken to the ballistic is a 9mm. Opposite to what the eyewitness, who was a friend to the deceased. Why are we taken for a ride like this? Why our justice system is made a mockery? Until when are we going to tolerate such a thing in our own country? Family, just drop your comment as to exactly how do you feel about what is happening in court. But to me, I feel Senzo is not sleeping, but is on his knees, watching everything. But we shall win, because the pressure we are putting at social media, they are feeling it in court. Family, let's keep pushing until we get somewhere. Justice for Senzo must be done. Ngiyathanda nonke ngothando lwalavu. Ngithi noma ngabe izindlu zodaka kusekhaya la. Let's keep fighting.